Good afternoon, Mr. Voss.
Good afternoon, Justice.
Why don't you get comfortable, and when you're ready, you can begin your opening remarks.
I'm not sure comfortable is the right.
Okay, when you get settled, you can begin your opening remarks.
That's probably more fair. Good afternoon, everyone. Thank you for the opportunity to be here. And also thank you for the work that you've done already to this point. This is a significant process and a good one, I think. But it's a good process because of the work that all of you have done in preparing yourselves for these interviews. And so I appreciate the work that you have done. I've appreciated the opportunity to visit with a number of you in the last couple of weeks, and it's been a good process. Last night was my turn to put the kids to bed. Wednesday night, my wife has a standing obligation. She plays clarinet in a volunteer concert band in Sioux City. And so when I got back from church on Wednesday night activities with my kids, it was my turn to put them to bed. So I got them snacks, and then I started the bedtime routine for my little girl, Emily, who's 5. She wants to be an astronaut. And so we brushed teeth, and then she looks at me and she asks, "Daddy, do you think Neil Armstrong was scared?" I think that was probably preparation for today. I had no idea where the question was coming from. And so I said, well, I'm sure he was scared sometimes, but he was also excited for the opportunity that there was in front of him. And that answer satisfied her, so we read books and sang songs and put her to bed, and then I came downstairs to write these remarks. We encourage our kids to dream big dreams. And so what Emily had figured out last night is that dreams can require courage to pursue. My dream was not to be an astronaut like Emily. My dream was a lot more mundane, perhaps. I dreamed to be a lawyer. It was the only profession that I seriously considered. I wanted to be a lawyer like my dad, because my dad was a lawyer. I never got to see him in practice, though, because he died of cancer. He was diagnosed with cancer when he was in his early 30s. He died when he was 33 and I was 6. But I mention that because my goal growing up and into adulthood was to live in such a way that he would be proud of me. So I followed his career path, going to law school, because I wanted to be a lawyer. I knew that without really knowing day in, day out what it meant to be a lawyer, because all I had observed of him was that he wore a suit, brought a briefcase home with him, and that he worked hard. But as I grew up, I was able to interact with clients of his, former clients of his, and without fail, they told me a couple of things. They said he was a good man and that he had helped them in some time of trouble or crisis that they had had. And so it struck me that the legal profession offers us a tremendous opportunity to be of service to people during those moments of their lives that are the most stressful and difficult. And as I was a freshman in college, I met, again, former clients of my dad. And these folks had him help them with an adoption. And so once they figured out who I was, they said, "You're Roger Voss's son." And then they called their daughter over to meet me and said, this is Joel Voss. His dad was our lawyer. He helped us adopt you. And that was significant for me because it showed me the impact that the law can have on the everyday life of people, of clients. This is something that will have a lifetime impact for them. And that's why I became a lawyer. I wanted to be of service to people. I wanted to be of service in a profession where that can take many forms. Sometimes it's litigation. Sometimes I mentioned the Munson versus Wellmark case as one of the significant cases that I had been a part of, because that was the first significant case that I worked on when I came to the firm. I'd been there about 3 weeks, I think, when John Gray brought a notepad with facts and said, figure out what we can do for these people. And so we sat down and worked through what we would file and where. It was an ERISA lawsuit that we needed to file to reinstate the private duty nursing services that had been cut off. And when we accomplished that, when the 49 hours a week that they were getting for their son, who was profoundly disabled, were reinstated, I will never forget the thankfulness of the client, because this had made a huge practical impact in their lives going forward. And it's not always that dramatic. Sometimes it's simply a matter of walking through doing estate planning with clients when the spouse has been diagnosed with cancer or Alzheimer's or Parkinson's, and just to explain what the process looks like, what the power of attorney should say, when it will take effect, and for the client to know that you will be there with them as they need to use it and go through the next phase of their lives can have a tremendous impact on clients. And so I've had that opportunity to be of service, and sometimes in significant ways, sometimes in ways that legally are not complicated, but still can have a significant impact on people's lives. And that it has mattered to me as much as the opportunity to do significant transactional work or the opportunity to do significant appellate work. I've had significant opportunities because of the firm that I've been a part of. Now, I like stability. I've been there for 16 and a half years. I've not had a job interview in that time period. I have the same secretary and paralegal that I started with. And so I think I work well with people. I've enjoyed this environment very much. But I think our dreams evolve and change. I still want to help people. I still want to use the law to be of service to people. But I want to do so in a position on the Court of Appeals. And in that, through the firm, I've had the opportunity to brief and argue a number of cases. I've been in front of this court. I've been in front of the Iowa Court of Appeals, the South Dakota Supreme Court, the Nebraska Court of Appeals. I've briefed cases for the Eighth Circuit, although I haven't argued those. And so through that work, I think I've shown the ability to analyze difficult areas of law, to construct good arguments that hold up both in briefs and under questioning from judges. And so I want to use the intellectual capacity that I have as an appellate lawyer to now serve the state of Iowa, serving as a judge on the Court of Appeals. I think that the Court of Appeals offers a significant opportunity to continue to be of service. It looks a little bit different, I think, than when you're in private practice. But when you're a judge, I think a well-written opinion which states the facts clearly and then carefully applies them to the law of the state of Iowa, I think that is good service to the community, to litigants, to lawyers. I think a judge who listens well, who is courteous to litigants, but still asks probing questions to determine the strengths or weakness of their arguments, I think that is significant service. I think a judge who decides a case based upon the facts without letting preconceived notions tilt the scales of justice either in favor or against any particular class of persons provides an essential service to litigants and to the court. And so I started my remarks by noting my little girl's question about whether Neil Armstrong was scared. I think one of the key characteristics of a judge, of a good judge, is courage. And that's something that we recognize actually in our statutes. Iowa Code Section 63.6 sets out the elements of the oath of a judicial officer in the state of Iowa. And it says this: I do solemnly swear that I will support the Constitution of the United States and the Constitution of the state of Iowa, and that without fear, favor, affection, or hope of reward, I will do my best. I will, to the best of my knowledge and ability, administer justice according to the law, equally to the rich and the poor. And it just struck me that fear is in there, that as something that we have to fight against. And it isn't necessarily intuitive at first, but I think to be a judge requires a courage that after you've analyzed the law, after you've analyzed the facts, you have to be committed to writing an opinion that is fair, but you have to stick to those convictions, as the oath says, without fear, favor, affection, or hope of reward, according to the law, equally to the rich and poor. If that would be my solemn goal, with courage and resolve, if I am chosen to be a judge on the Court of Appeals. With that, I would respond to any questions that the commission may have.
Thank you very much, Mr. Voss. Mr. Gray.
Yes, I abstain.
Mr. Harbach.
I have no questions.
Ms. O'Brien.
Mr. Voss, I think you were a little modest in your recitation of the facts around, and the law around the ERISA case, and would you please tell the commission a little bit about the standard of review and the sort of overwhelming obstacle that you face?
Sure. The standard of review in an ERISA case is very deferential towards the administrator of the plan, and particularly if they have written into the plan document that they have discretion in how they interpret the plan document. And this was a well-marked plan. It was well written from that standpoint, so it was a very deferential standard. It had to be essentially an abuse of discretion where no reasonable construction of the facts would lead to the conclusion that the insurer had reached. And so, if I was modest in the recitation of the facts, Max Munson, the child involved here, had spastic quadriplegia, cerebral palsy. So he was profoundly disabled. He was in a motorized wheelchair. He had a trach tube and was on oxygen. And so it was only with great effort that his parents, who were determined to give him as much experience as you could as a child with those disabilities, only with great effort that they were able to take him out of the home infrequently. But it was based on their extraordinary efforts that they had been determined that he was no longer homebound. And so that was the interpretation that we had to overcome. Certainly it was possible for his parents with great effort to bring him out of the home. But what Judge Bennett found was they were essentially being penalized for being very good caregivers. And so it was a rewarding resolution to see when good deeds don't get punished, if you will. So.
Thank you.
Mrs. Roberts? Ms. Conover?
No questions.
Mr. Bloom?
Yeah, just a couple of things that popped out I wanted to mention. In discussing with you, first of all, I think your introduction gave us a good idea of who you are. And in our discussions, I asked you some questions about how you ended up going to Iowa Law School and where you had stellar academic results. And you mentioned that you'd been accepted at Chicago and Notre Dame. And for really personal, family, common sense reasons, you ended up going to Iowa. You said it was just, you didn't need the ego trip, I think, was your comment to the others.
I did say that.
And then in asking you how you ended up at your current law firm, you mentioned, that, it was partly in combination with your wife's career. So, we frequently talk about, issues where, and I've seen this in my own daughters, my wife as well, who sacrificed career opportunities on behalf of maximizing the family. We don't often talk about fathers and husbands who do the same thing. So I just want to recognize that on your behalf, in addition to your stellar academic record and excellent professional success as an attorney and appellate record. So I think that tells you a lot about who you are as a person, and I thought I just wanted to share that with the rest of the commissioners. I don't know if they had that same discussion with you, but it's not really a question, it's more of an observation.
Well, I appreciate the comments and the observation, and I will say it's no sacrifice to practice with the Heidman Law Firm.
No, I wasn't.
I'll get you working with Mr. Gray. That's fine.
But I do think that as far as decision-making, we never make decisions in a vacuum, and I've always tried to, certainly when we were making the decision about where we would go after law school, one of the things we were weighing was whether to look at clerkships or not. And my wife was graduating from the University of Iowa with her Master's of Library Science at the same time, and we thought it would be difficult for her to start her career maybe with a 1-year commitment before we landed where we were ultimately going to make a career for ourselves together. And so we did not look at at clerkships at that point in time, because it made more sense for us as a married couple to start our professional lives together at the same time.
Mr. Goodman?
Mr. Voss, thank you very much for your application. I think you and Tim Garten share something in common which is unique to this commission, and those are lawyers who have a transactional background, so I commend you for applying. My eyes have been kind of open to the advantages of a justice or a judge on the Court of Appeals that might have that kind of background. Yours is more mixed and blended, 55% transactional, 40% litigation. Can you share with us what you think what difference that would make on the Court of Appeals, recognizing that 38% of the cases are criminal, 34% are domestic? And I don't ask that in a challenging way, but more of a way to enlighten this commission, because I do think there's such a thing as a problem solver, and whether you're solving a problem for a transactional client or litigating a case to overturn an ERISA decision, it's essentially the same activity, and maybe on a bench, the activity that goes on in the mind and comes through the pen might be the same thing. Can you address that
Sure.
point?
Well, and thank you for the question. I would say, in looking at the workload of the Court of Appeals, the law is such a broad area that no one, I think, can claim to be an expert in everything. And so I recognize that there are areas where I have relatively less experience, and I will need to work hard to bring myself up to speed. But I do think it is significant to have someone on the Court of Appeals who has transactional experience, because that is, it may just fall into the 16% of other civil cases but that's still 16% of the caseload of the Court of Appeals if you look at their decisions in the last year. And so to have someone who is familiar with the real estate and contractual realms and speaks that language kind of as their native tongue, I think, is an asset to the court. When you look at the current composition of the Court of Appeals, I think there is significant expertise in the family law and in the areas of criminal law. And so I think that I can complement that by bringing in subject matter expertise in an area that is not currently that same depth of experience. So that's what I would hope to do, to diversify the knowledge base, if you will, of the Court of Appeals.
Thank you. Ms. Diekma?
No questions.
Ms. Sinclair?
Have you ever applied to the district court, and if not, why not?
Sure. I have not applied to the district court. I have great respect for district court judges. They are perhaps the generalists in the truest sense of the word, that there's a lot of different things they get thrown at them in a particular day. I think one of the reasons why I had not applied to the district court is that the jury trial is it's a real art form when it's done well. It requires significant expertise on the part of the judge in terms of handling the rules of evidence and the evidentiary objections that you have to make on the fly relatively quickly. And that is that's something I have relatively less exposure to as a lawyer who's does a lot of transactional work and does a lot of appellate work, but relatively less trial work in the court system. And so there would have been a learning curve there for me, and the issues that come to a court on the appellate level come at you, if you will, at a different speed. They're not less significant, but you have the opportunity to reflect and study before you have to issue your ruling. And so I've always thought that my skill set was better suited for the appellate level than the trial court level for that reason.
Well, we've run out of time, and I really appreciate you coming, and we wish you the best of luck.
Thank you.
Thank you.